It's here for insembi kosu insembeya. Na answer kwa kubo audio no amamatino. Message notification button no turn on. So the any update be bia unsa beka na wahwe. Na wa like wa subscribe ama bibia aye kama. Menjibre niekutie insem kakra ewo hono.
By a private citizen, Theodore Kofi Atakwati, who is asking the court to place an interlocutory injunction on the hearing by the Committee of Inquiry as part of processes for removal of the Chief Justice under Article 146 of the Constitution pending the determination of the instant action. The plaintiff is also asking an order suspending the operation of the warrant of suspension issued by the President against the Chief Justice. Legal Affairs Correspondent Latif Idrisu joins me from court with more updates. Latif, has court started already and what's happening so far?
Yes, MFA. So the particular case you just cited in your intro is not yet on the banner at the Supreme Court. What is being heard currently is a case brought before the Supreme Court by the Center for Citizenship, Constitutional and Electoral Systems. Now, this group, the thrust of their case is that the President of the Republic, John Dramani Mahama, failed to furnish the suspended Chief Justice, her ladyship, Justice Gertrude Tokonu, with copies of the prima facie determination that was made against her, reason why the President went ahead to set up the committee that is currently undertaking its work. So what this group is asking the Supreme Court to do is to impose an interlocutory injunction on the processes, including the injunction on the committee that is currently hearing the matter. So it's asking for that, and then subsequently, this same group is hoping that a forum will be given to them to make a case for the entire process as initiated by the President to be quashed. And that is the case that is currently being heard. We heard from the lawyer for the plaintiff who made the case that indeed, as far as they are concerned, they are aware that the President has not furnished the suspended Chief Justice with a prima facie determination. Now, then come in, now before I even go there, this rate has the Attorney General as the first respondent. It has the suspended Chief Justice as the second respondent, and it has the chairman of the committee that is hearing the matter, Justice Scott Krom of the Supreme Court. These three are respondents. Now, we heard from the lawyer for the plaintiff, and then we heard from the lawyer for the suspended Chief Justice. Now, he made a sharp contrast to what the lawyer for the plaintiff had said, because according to the lawyer for the plaintiff, the President failed to furnish the suspended Chief Justice with a prima facie determination. Now, lawyer for the suspended Chief Justice comes in, and his argument or his submission to the Supreme Court panel is that there has not been any prima facie determination as far as he is concerned. And I must reiterate, this is the lawyer for the suspended Chief Justice speaking. He says in his submission that as far as he is concerned, there has not been any prima facie determination by the President. If there were any such determination, it would have been captured in the communication between the Executive Secretary of the President to the Chief Justice. Now, the argument here is that if he did that, and I'm referencing the Executive Secretary of the President, if he did indicate reasons for the suspension of the suspended Chief Justice, that will be giving out details about the petitions. So his argument to counter that is that as far as he is concerned, the in-camera hearing about this whole petition and the hearing has to do with the in-camera hearing or the processes that is being undertaken by the committee established by the President, and not the communication as was done between the Executive Secretary of the President and the suspended Chief Justice. So the arguments have been made, and before I stepped out of the Supreme Court, Justice Shemsai, who is representing the Attorney General, that's Deputy Attorney General Justice Shemsai, was on his feet to make his own argument for the state on this particular matter. So the earlier one that was expected to come off has not happened yet.
Okay.
This is the latest from the...
In this case, the Lord Chief Justice. When the petition gets to the Council of State, the Council of State must see whether or not the petition is frivolous or whether there's something to answer. If the Council of State comes to the conclusion that there is a case to answer, with the lawyers call in Latin prima facie, then the Council of State, together with the President, will set up a committee. The Constitution proceeds to delimit who and whom can be on the committee. It says that there should be 2 Supreme Court judges on the committee, one of whom is chairing it, and the other. And then there should be another person, and there should be 3 other people who are not members of the Council of State, and who are not members of Parliament, and who are not lawyers, members of the Ghana Bar Association. So in fulfilling the constitutional righteousness, John Dramani Mahama, together with the Council of State, having told Ghanaians that they have already established a prima facie case, then set up a committee of 5 members. Chairman of the committee is Mr. Gabriel Scott Puaman, who is the chairman of the committee, but the Supreme Court judge, a very senior Supreme Court judge, I have to say, and also a member of the PNC. We know Gabriel Puaman would like us to mention that he's a member of the PNC. And then there's also Justice Asiedu, who is on the committee. So the 2 Supreme Court judges fulfilled. Then our own Domelevo, I'm looking to meet with him. You know, we had a lot of fights back in the day when Akufo-Addo was trying to remove him, and he said he wouldn't go. And people like us were fighting on the side of Akufo-Addo. And eventually he was removed. But I went to the Supreme Court and we lost. We accepted defeat. But it was too late because he had already passed the retirement age. He was out. So I'm looking for Domelevo so that we can spy a little bit. So Daniel Domelevo is also on the committee. And then there are 2 other people on the committee. Okay. So on the first day of hearing, on the Thursday morning, we've already told you what happened. They wrote a letter to the Chief Justice. They didn't add a venue. Later on, they added a venue in this, you know, I can't say obscure, but in some venue near the Osu Castle. When the sitting opened that morning, the Lord Chief Justice was not present, but her lawyers were present. And as the story goes, the panel told the lawyers that if the subject is not here, we will not hear you. The lawyers were quite bemused because letters had been written to them that they should appear on that day. Some of the letters were addressed to them, so that the panel were aware that they are the lawyers for Gertrude Tokonu. Gertrude Tokonu was not there, and they said that they would not hear the lawyers, and the lawyers should clear off. Go and bring Gertrude Tokonu. If you don't bring Gertrude Tokonu, we are not going to hear you. Get out of here. It was quite hostile, and the lawyers for Gertrude Tokonu were very bemused. And they were quite surprised because regular court practices, the subject is usually not usually, but sometimes not there. Okay, so the matter ended at around midday or 1 o'clock. And then, as the petitioner says, 6:30 p.m., between 6:30 p.m. and 7:30 p.m., there was this dramatic entry into this restaurant at the airport's residential area. Gabriel Scott Puaman was there. Asiedu was there. Who's calling me? I'll call him back. Somebody's calling me. Oh, boss. Okay, I'm on TV. Hey, this matter is getting hot too. All right. So Gabriel Scott Puaman was there. Asiedu was there, and who's the third person? Justice Kulendi, who is not sitting as part of the committee. He's not. He's a very distinguished Supreme Court judge, Justice Kulendi, on the left of your screen. Justice Kulendi was also there. Now, why is Justice Kulendi important in the allegation or the allegation of collusion? Because Justice Yoni Kulendi was one of the 3 judges who gave that expert opinion blocking the injunction that had been filed to injunct the committee's work. There was an injunction filed by the Supreme Court to injunct the committee's work on the basis that President Mahama had jumped the step of not giving Justice Tokonu the document. Now, that Supreme Court decision was a 3-2 decision. 2 of the judges agreed with the applicant who filed the injunction, Mr. Asifo, a member of Parliament. That application was argued by the learned Godfrey Dami, the former Attorney General. Now, Justice Kulendi ruled on the side that the injunction should not fly, and he was with the 3 and the 2 others. So Justice Kulendi, according to the story, was part of this dinner And then Mr. Thaddeus Sorry was also part of the dinner. The problem here, the allegation of the problem, that if all these facts are true, then there should be some concern as to why Justice Scott Praman, who is chairing the committee, and Justice Asiedu, who is the other Supreme Court judge on the committee, are seen together with Thaddeus Sorry, who is counsel for Daniel Ofori, and which Daniel Ofori has had a major tussle in the court over this EcoBank matter for a long time. And then on most of the Daniel Ofori tussles, Gabriel Scott Praman has ruled in favor of Daniel Ofori, and Daniel Ofori has perceived Justice Tokonu as a major enemy in his quest to secure $97 million Ghana cedis from EcoBank. Daniel Ofori perceives Tokonu as an opponent to this matter. Tokonu has a reasons for opposing the matter on the basis of law, on the basis of calculation of compound interest, and all of those matters. Justice Tokonu has a firm, clear view on that matter because she came out of the commercial court and she's well versed in these things. But let's leave that for now. So this is the reason why eyebrows could be raised if it's true that all of these four men had met together having dinner on the same night after the committee refused to hear Justice Tokonu. This is the story. Now, the petitioner went to the president and petitioned, and the radio newspapers were carrying the story. And so this morning on his Facebook page, can you put that? Thank you very much. On his Facebook page, Thaddeus Sorry wrote this: "It is a monstrous lie. No such meeting took place. It is very easy to fact check that. We know those who get justice through negotiation." I don't understand the second part of Thaddeus Sorry's thing. He says, "We know those who get justice through negotiation." I'm not sure who he means or what he means, but he's a very senior lawyer. So, I mean, I know he knows what he's talking about. But the fundamental thing that Justice Sorry says here is that there was no such meeting took place. In Thaddeus Sorry's comments, we don't know whether he means that he was not at the restaurant, or that he was not at the restaurant that day, or that he was there but the other judges were not there, or that the other judges were there and he was not there, or that he left before the other judges came, or that they came before he left, or that they were all there at the same time but they just talked about something, or that he was there and he met somebody else and the judges were together somewhere else. We don't know all of those details. So on this note, let me go to the petition and let's see what the petition says before we go to speak to the petitioner at 25 minutes past 11 o'clock. Let's get the petition now. So the petition is P.O. Box 622 Adenta, Accra, 19th May 2025. His Excellency John Dramani Mahama, President of the Republic of Ghana, Jubilee House, Accra, comma, Your Excellency, comma, read petition for the dissolution of committee formed under Article 146 of the Constitution to inquire into the petition against the Chief Justice as follows. Is by Mr. Kumi. Respectfully, comma, I'm a citizen of Ghana and one with keen interest in the protection of the Constitution, particularly all steps taken by the President in furtherance of his duty to execute and maintain the Constitution and the laws of Ghana pursuant to Article 58(1) of the Constitution of Ghana. On 22nd April 2025, the spokesperson to the President informed the nation of the composition of a 5-member committee under Article 146 of the Constitution to inquire into 3 petitions for the removal of the Chief Justice, Her Ladyship, Justice Gertrude Araba Isaba Tokonu. The members of the committee were stated as Justice Gabriel Scott Praman, Supreme Court Judge, Justice Samuel Adibu Asiedu, Supreme Court Judge, Daniel Yao Domlevel, former Auditor General, Major Florence Bazwanura Dalugu, member of the Ghana Armed Forces, Professor James Sefa Jifa, Professor, University of Ghana. That's the 5. The spokesperson to the President followed up with another press release on 14th of May 2025, in which he indicated that the committee will hold its first sitting on Thursday, 15th May 2025. Respectfully, comma, I deem it my duty to bring to your attention the conduct of some of the members of the committee set up by your good self, which clearly has compromised their fairness and has brought the committee into disrepute. In the evening of 15th of May 2025, between 7:30 and 8:30 p.m., Justices Gabriel Praman and Samuel Kwame Adibu Asiedu, together with Justice Yoni Kulendi of the Supreme Court of Ghana, were seen having dinner with the counsel for one of the petitioners before the committee, Mr. Thaddeus Sorry, at the Santoku restaurant located at Villaggio Airport Residential Area, Accra. The strange meeting of the 4 persons who are keenly interested interested in and have played and indeed continue to play critical roles initiated in the processes for the removal of the Chief Justice excited the curiosity of some persons in the restaurant. Indeed, they were overheard discussing matters relating to the petition. Respectfully, the record of the presence of the 4 justices, Puaman, Kolendi, Asiedu, and lawyer Thadiosori at the restaurant and the meeting they had can easily be verified and confirmed. I like that. The above development is of grave worry, as proceedings for the removal of the Chief Justice of the Republic of Ghana is very solemn and serious process and should not lend itself to manipulation by any person or authority. The meeting between Justice Puaman, Kolendi, and Asiedu with Thadiosori clearly has destroyed the integrity of the process and reduces public confidence in the process so far. Both Justices Asiedu and Puaman are members of the panel set up to inquire into the petition. They have no business meeting counsel for one of the petitioners outside working hours at the unofficial place, a restaurant, and to have a discussion. This is more serious when the record shows that Justice Puaman gave judgments in favor of the same petitioner, Daniel Ofori, represented by the same counsel, Thadiosori, in Supreme Court. Justice Tokonu, the record shows, rather gave opinions against the said Daniel Ofori in one of the cases. Further, Justice Puaman is known to be interested in becoming the Chief Justice following your election as President of the Republic. That's interesting. The petitioner is telling the President that, Mr. President, but you know that Justice Puaman, since you became President, he wants to be Chief Justice, you know. But that's really what he's saying. Mr. President, why? You don't know. You know that Puaman wants to be CJ, you know, because you were elected, you know that already. All right. Justice Yoni Kulendi is widely known to have been a close rival of Justice Tokonu for the position of Chief Justice when same became vacant after the exit of Justice Kwesi Eniyebua. He, Kulendi, lobbied vigorously for the position but was disappointed by President Akufo-Addo. It is therefore not surprising that he voted with alacrity against the plaintiff Vincent Ekwa-Asefua to dismiss an injunction application filed by him to restrain the taking of further steps under Article 146 until the suit filed by him to challenge the process is determined. Clearly, he has an interest in seeing the exit of Justice Tokonu as Chief Justice. He is known to be interested in being appointed Chief Justice. Justice Samuel Kwame Adibu-Asiedu is also on record to have been one of those who actively lobbied to be Chief Justice after the exit of Justice Eniyebua. He was also, however, disappointed by President Akufo-Addo on account of being far junior in the Supreme Court at that time. He thus has a personal interest in the removal process underway. Respectfully, in view of the matter set out above, the membership of Justice Puaman and Asiedu of the committee set up by your good self is an affront to justice. The meeting they had with Thadiosori at Santoku restaurant on Thursday, 15th May 2025 clearly brings the administration of justice in the 3 petitions into disrepute and compromises their ability to efficiently discharge their duties to the Republic under Article 146 of the Constitution. Their conduct is deplorable and most unbecoming of justices occupying the highest court of Ghana. It has therefore the tendency to show that the whole process, quite unfortunately, is a sham. In the interest of preserving the integrity of the process, I hereby petition you for an immediate dissolution of the committee as